You all have cards on your seats. If you want to ask a question, we'd prefer you put your question on the card, and I'll come around, or some of us will come around and pick up the cards.
Dolores not. She's going to work that side, and I'm going to work this side. You'll pass your cards to the right on this side, you'll pass them to the left on that side. We'll pick them up, and then we'll get more questions presented to the panelists.
While we're doing that, I'm going to ask a question of the panelists and give us a little time to collect all the note cards. We've heard each of them talk a lot about the selection process and how that differs in different court systems. With the exception of the Court of Appeals right now, if you're in a merit selection system like Johnson County is and like the Supreme Court is, you're going through that nominating commission process. And all three of you have been through that in one way, shape, or form, and I think Judge Arnold-Burger has been involved in that from two different perspectives at least. And the primary criticism that you hear from those who want to change that system is that it's a system that is dominated by the lawyers. And you really have the lawyers that are making the decisions upon who is going to be that next judge or justice. And I'd like to ask each of you to comment a little bit on that proposition or allegation that is made and how that fits with your experience in working through that process.
Well, let me start. I went through the process twice because I didn't get it the first time. Both times, and all I can do is speak from my experience, both times the lay members of the panel conducted themselves exactly the way you would want. They vetted, they called. There's a little bit in this process where some lawyers will call the lay members, or all the members actually, and express their opinion. I'm not talking about the lawyer members of the nominating commission, but just lawyers in public. And, so that always happens, but I never got the feeling that the lay members of the panel were anything other than independent thinkers. But that doesn't matter what I think, because they are open deliberations. You can sit there and watch whether you think somebody's getting beat up or not. I would suggest to you that doesn't happen.
I would say from being on the nominating commission in Johnson County, where we have the biggest nominating commission in the state with 14 members, 7 lawyers, 7 non-lawyers, it was really an equal involvement by both. As Judge Ryan said, we assigned a lawyer member and a non-lawyer member to each candidate so that they could each review that. All I need to tell you is Janice McMillan was one of our non-lawyer members. If you think we were able to shut her up here. So, and the other thing I would say is, one, the people of this state in 1957 voted that was the process they wanted. They wanted to have lawyer members and non-lawyer members. And the other thing I would say is, when you want to decide what surgeon you want for your surgery, you don't ask your plumber. You ask another doctor. And likewise, if you want somebody that's going to be a judge, doesn't it make sense that you would want to have some solid input from lawyers that are before those judges all the time? And the last thing I will say is, it is a terrible misperception to think that lawyers think the same way. Because lawyers on the nominating commission in Johnson County, lawyers on the Supreme Court nominating commission are just as diverse as the general population. You have lawyers that represent criminal defendants. You have lawyers that are prosecutors. You have lawyers that represent doctors in malpractice cases, and lawyers that represent individuals that malpractice has been committed against. So there are a wide variety of opinions from those lawyers, just as there are from the non-lawyers on the commission.
The only 2 cents I need to add to that is, first, a point that Karen brought up is lawyers know more than other people, whether it's election or you going and putting your yes or no on the retention ballot, lawyers deal with other lawyers. Lawyers are appearing, the lawyers who go to court, as I said, it's not every lawyer. Litigators appear in front of judges, and they know, they experience, they have the firsthand knowledge of how these judges act. Are they competent? Are they timely? Do they know the law? Do they apply the law to the facts? Do they listen to people? So there needs to be lawyers as part of that group. And I'll just say from my own experience and the non-lawyer, the citizen members of Johnson County District Court Nominating Commission, not that they were tougher in any way, but I found that not only were they informed, not only about me, but about the process, but they also asked questions that, in many ways, kind of blew away the lawyer questions. The lawyer questions, you kind of know how to answer those because you're given kind of like you're in court. The citizens ask the questions that I think catch people off guard, and maybe a more insightful way of, during those interviews, for the lawyer to have to react and say, well, you know, either in what you say or what you don't say, because what you don't say is a lot of times just as important, because you can't comment. You know, they're not asking for your personal beliefs, but it might be important to know that, well, I'm not going to comment on this because that's not really what my job will be. I may not believe in this law, but my job is to apply the law. And the citizens tend to ask not esoteric questions, but more practical questions, really. So that's my take on it.
Might just add one thought to that. I've always thought that those who are arguing that the lawyers have too much influence somehow think that, well, if the lawyers have too much influence, then they're going to get judges who are going to produce pro-lawyer opinions. Well, what in the world is that? I mean, I can tell you that lawyers are all over the map. And you have criminal defense lawyers, you have insurance defense lawyers, you have family law lawyers, and all of them sometimes want to see a lawyer who practices in their area who is going to be part of that nominating commission. So there's a great deal of conflict just among lawyers out there. This is a really simple question, but I think is a great question. And it's oftentimes talked about sort of in the rhetoric that you hear about judges these days, and is, what is an activist judge?
Again, the district court level takes the battlefield first. An activist judge is a judge who doesn't decide the way you want it decided.
I thought about this driving in today, and it's a question that we get from time to time. Right, there used to be a real answer to that question. I mean, there was an academic concept about judges who would reach further than the case required to decide point X over here because it was a bright, shiny object that they wanted to decide. And I would suggest to you that that occurs both liberal and conservative, whatever that means. But now it's sort of morphed into activist judges are those who don't follow Kansas law. I don't know quite what that means, but let me give you an example. I wrote a decision that was published yesterday involving an underground mine and whether limestone had been your case. It doesn't matter what the facts are. The district court ruled on two different points. And it doesn't matter what they are. Two different points. The folks who lost appealed to the Court of Appeals. Judge Arnold-Burger wrote the opinion. She reversed, and her colleagues, it was a unanimous decision, they reversed the district court on one point and affirmed on the other. My question to you is, did the district court judge follow Kansas law? Is that district court judge an activist judge? Now, The Court of Appeals decision, the losing side, or maybe both sides, both sides, I think both sides,
I didn't make either side.
came to us. Both sides, anyway, petition for review came up. We granted it, and we looked at the case, and I issued an opinion yesterday. And on the 2 points, our court unanimously said, on the one point those two agreed on, they were wrong. And on the one point, the Court of Appeals said the district court was wrong on, we said that the Court of Appeals was right, but they took too long to answer the question. It was a simpler question than they made. That doesn't matter. Is Judge Arnold-Burger an activist judge? Did she follow Kansas law? Again, how do you do that? And I would suggest to you, and the reason there's a profession with people that argue, and you get a brief on one side and it says this is Kansas law, and you get another brief that says this is Kansas law, picking the winner there does not make you an activist judge. And so, I mean, that's the complexity of what we go to. So it doesn't boil itself down to labels like that, I think, as easily as some might want. So again, I think more often than not, it gets you back to Judge Ryan's point, was an activist judge is the one that ruled against you.
This is a question about efficiency in the courtroom, and Justice Biles, I think you mentioned this is kind of one of your criteria that you ought to look at about performance. And the question really is, how long should it take for a case to work its way through the system? I know it's kind of a difficult question, and because cases are in all different shapes and sizes, but what about these cases that just sometimes take years to get through the system? And is the old saying of justice delayed is justice denied. You might just comment a little bit about, I think, the efficiency of the court system and getting cases resolved in a timely manner.
Since I didn't answer any of the last ones, I'll start with that. Well, efficiency is very important to the court, and there are time to decision standards that the district court judges adhere to. We have time to decision standards that we try to adhere to in the Court of Appeals. Once the case gets to us and we have argument, we render a decision within 60 days. That's our own personal time frame. But lots of things happen to a case that cause delay. Sometimes it's the parties need continuances. They need more time to write their briefs. So that can cause delay. The case may come up to us like the one that Justice Biles just talked about. It was a long, complicated case. It took several days of trial in the district court. Took a long time to brief and get ready in our court. Then they filed a petition for review and get it to Justice Biles, and now he's sent it back. Their panel has sent it back to the district court to do some more things with it. So I'm sure somebody will be unhappy with how that comes out, and they'll appeal it to the Court of Appeals, and then it'll come back to the Supreme Court. So you get to the last time it gets to the Supreme Court, and you think, oh my goodness, this case has been pending for 8 years. How can that be? Well, it's had a long, torturous history. And I would say that is, those kinds of cases that take that kind of length of time are rare. And they're usually very complex cases. Otherwise, on a day-to-day basis, the thousands of cases that we each decide and are involved in every year get through the court pretty efficiently, I would say.
One thing to remember also from the district court level is not only the volume. I was just looking at our numbers between 23 judges in Johnson County. This is from 2014 or 15. We decide over 44,000 cases in a year between 23 judges. Now, some of those are traffic cases, because we do have a traffic portion of the district court as well, if it's something that occurs outside of a municipality, outside of a city limit. But that's including contract cases, medical malpractice cases, some things that are simpler, limited actions, but it's just as important to the people that are there as a multi-million-dollar case. So we have to take every case as it comes in. And I think the other important thing from at our level is if it is a complex case, it's complex because in many ways the attorneys and the parties have to go through discovery. They have to be able to get their information so that they can present it at trial. And it's not unusual for discovery. I'll just use a medical malpractice case, for example, to get all of the records, review all the records, retain experts, depose, take depositions of the experts so they know what they're going to testify to, and finally getting to trial for a 2-week trial to put on the court's calendar. That may take 2 years to get to that point. Now, that's an unusual case, but most cases are resolved at the district court level. I would say, this is just from my own experience, I'd say, anywhere from 6 months to 9 months, outside a year. But a lot of that is we in criminal court, we have to adhere to state and federal constitutional law. For instance, a right to a speedy trial. So many times we'll say, we've got these other jury trials scheduled, this person's in custody, they need to go to trial, we wipe the other ones out, and we'll try that case. So it's always juggling all those issues. It's not just simply, well, we don't feel like really working hard today, so we'll put it off to next week.
I think ultimately the responsibility for processing cases falls on the court. That said, we rely, because of these volumes of stuff, we rely on the lawyers. Because if one lawyer asks for more time and the other lawyer doesn't object, you know, in some respects, who are we to tell these guys, you know, no. And that's true on a small case. It's true on death penalty cases. You know, you hear people talk all the time, why does it take 10 years or 15 years for a death penalty case? You know, if you peel back the layers of the onion, the very first thing you want to know is who asked for continuances, because if you follow our rules, you're going to get through the system just pretty fast, because we have set deadlines in the rules. So somebody has to hold up their hand and say, there's 150 issues in this case, and the trial took 6 or 7 weeks. We can't do that in 60 days, so we need more time. Okay, what's the other side say? If it's the criminal defendant asking for more time, what's the state say? And then vice versa. So now at some point, the court has to go, whoa, you know, this is just really going on too long. In the death penalty cases, that's what we did. When I got on and when Chief Justice Davis took over for Chief Justice McFarland, I took her place. The very first thing that they started doing, and then he got sick and Chief Justice Nuss took over, but the thing we did was have status conferences on all those cases. And they had whiteboards up in a room and had telephone conference calls back after back. And the first thing was to the first lawyer saying, how long is it going to take you to get this brief done? And no excuses after that. Just give us a date, but no excuses after that. And you do that, and you go back to the other side, and you go back and forth. When you're processing a case, after the oral argument, we try to get our cases out. You know, I think for me, the average is 90 to 150 days, somewhere in there. At the Johnson County Bar Lunch, where I appeared just a couple days ago, I told the lawyers that regardless of whether it's me or anybody else in the court, if you don't have an opinion from the last docket out today, you don't have an opinion in your hand, it's because we're stuck filling in one issue. We're waiting for the United States Supreme Court case that we know about. We're waiting for something. We're waiting for, or we've got 4 or 5 cases with the same issue, and one case is going to be the lead, and so we're waiting. So I have several cases completely written with one little blank that says this is the same issues in this case, same result. So I like to have all of the cases from last docket done before we start the next docket. Again, making a plug for our live streaming. Our first case next Monday morning is going to be a gentleman who says, why after 4.5 years did I not get a trial when I'm accused of being a sexually violent predator? And there'll be, both sides are going to stand at the podium and point to the other guy. And we'll have to figure out where that all lies.
I'm going to ask one more question, and then I want to move to just give everybody an opportunity to have a quick closing remark here. And this is kind of a two-part question. I'm going to combine these two, and they may or may not be related. I think maybe it was Judge Ryan who was earlier talking about the history of the decisions that have been made in Johnson County about what system we're going to have here. And I think one of the things that was noted was the percentage of people who are voting in favor of the merit selection system has been falling over time. And so I want to ask each of our panelists what they might attribute that to. And then what I think may be related to this is one of the concerns that I certainly see as a lawyer is that there seems to be a bit of a declining interest among lawyers in serving as a judge. And as I see when there are openings, that there are fewer people who are applying, and as one who usually knows most of the people who's applying, sometimes the quality is not what you want it to be. I know that there was a recent opening, actually a current opening in my judicial district in Douglas County, and a number of us made a few phone calls trying to say, hey, why don't you put your name in? We think you'd be really good. And people would say back, well, I just don't want to do that. I don't want to deal with the process. It's a pay cut for me or something like that. So I'd be curious to what your thoughts are on those issues.
Our leader.
I really think there are two questions there. The first has to do with the public interest and frankly, what's happened with what's been going on has been complacency. We all forgot the lessons we learned in 5th grade about the branches of government, the separation of power. And I told the lawyers at Johnson County the other day that when we had the last vote, and I was not on the court then, I was in private practice, and so I was supporting the merit selection process. The first big boulder we had was informing the public about what was going on, because we all kind of forgot about it. The court system became something that we saw on TV between Law and Order and CSI and LA Law. And so what's been nice about the last couple of years is that the interest has gone up. I've certainly spoken to more Rotary groups, civic groups, and people come and they're interested in revisiting. But invariably what happens is when you say something, they go, oh yeah, I remember that. And then frankly, they almost become patriotic about their court system. So that I think is the one thing that's going on. In terms of, and do not think I'm lying, but in terms of getting quality judges, the truth of the matter is I took this job in 2009, I took a cut in pay, and I haven't had a raise since, and I got 2 kids still in college. So, I'm cannibalizing a lot of what I did before I got there. But that's the reality. And I'm the judicial department for Southwest Kansas. And we've literally had applications for judges out there where you get just a few. And that's not good to not have, a choice. And it's not because there aren't too many people out there. It's just folks can do better than taking this job. So, I think that is a relevant discussion to put into the public discourse.
I would agree with that, and also, I'm not whining or complaining. None of us have gotten a raise. None of the court employees have gotten a raise. It's not just us. But, and I would, please don't tell the governor this, but I would take this job regardless of the salary because I'm not in it for the salary. But judges in Kansas, I think you need to know, are now ranked 50th of the 50 states. We are the district court judges in Kansas are the lowest paid judges in the nation. If they can get more money as a new lawyer out of law school going to a law firm, why would you do this?
Well, there's certainly the aspect that it's a public service. That's why people get into it. This is my own personal opinion. It's like many things in our whole culture. Way back when I was a little kid, even, you think of the doctor. They're kind of held up on a pedestal. Your parents would say, "Well, that's what the doctor said. You better do it." Nobody got a second opinion. That would be offensive to the doctor. Well, it's the same thing. Lawyers as a whole, as a profession, people look at it and say it's more of a business. It's not really the whole profession idea as much anymore. People don't hold attorneys, obviously, in highest esteem, and judges are right there with them. So there's that aspect of, as we continue, more generations coming up, they're not as interested. But I think, I just know my own personal experience when I went through the process in 2007 and 2008 to become a district court judge. There were 2 spots open the first time I tried, and there were, I think, a total of 42 applicants for 2 spots. Now, they ended up choosing 4 of those 42. 3 went up to the governor for the first selection, and then of the 2 that didn't get picked, the 4th person joined them for the second. And it went down, and I think it was about, when I was chosen, there was a group of 25 that applied that time. In Johnson County, you can look at the numbers, you can look at that on the website of the nominating commission on the minutes. It shows the number of people who applied. And this, I think, 10 is the lowest. We've never gone into single digits, but for an open judge position, district court judge, this is the lowest that we've ever had.
I think we are out of time here, but I want to take the moderator's prerogative to just make one quick last remark. I hope that you've gotten a lot out of this today. I know that I certainly have. And as we approach November, we oftentimes don't like to think of politics and the judiciary being put together, but unfortunately that is going to be the case. There's going to be probably hundreds of thousands of, if not millions of dollars that are going to be spent talking about whether these folks and their colleagues ought to be retained in office. And those ads are going to skew what has probably occurred in their courtrooms, and it's going to focus on one individual case and not the whole body of work that they have had during their careers. And I think it's incumbent upon all of us to remind our friends, our neighbors, our co-workers, our family members that these retention elections are very, very important. And while, when they go to the ballot box, they're clearly going to recognize Donald Trump and Hillary Clinton and some of the other races, they need to vote all the way down the ballot. And I think we're going to have, this is what I have often said around the state, a lot of important elections out there. I think, frankly, the retention of our judiciary may be the most important election in Kansas in 2016. So I want to turn things back over to Ann, and thank you all for being here, and thank you to our panelists.
I'd like to thank our panel. They were very thorough. They brought us new understandings and new insights. And I believe that all of us know how important it is to have a fair and impartial judiciary. And the merit selection, we heard it is a very thorough process. So I believe that all of us have been informed, and we appreciate them taking their time on a Saturday morning to come and speak with us. We always give to our speakers a big gift. It is a pin, but it's a unique pin because it says LWV, League of Women Voters, shedding a light on democracy. And there is actually a little light at the end of each of the pins. In all respect for our mayor, Ed Eilert, he has a comment that he'd like to make to the league, and we know that there's an important question on the ballot as well. And so he is making his way forward. And what we're going to do with the questions that you had out of respect is that we're going to collect them, and we'll see what we can do about getting some answers to your questions so that you feel that your time was well spent, okay?
Well, thank you very much, and I will just take a few moments. Let me say congratulations to the panel. They did a terrific job. You know, someone said once a mayor, always a mayor, and that's fine with me. But after I got done being a mayor, I was elected to the county commission in '06, and currently serve as chairman of the county commission. You know, we are kind of at the very basic level when it comes to the court, but we do have a responsibility. And that responsibility is to provide an appropriate facility for the district court to carry on its activity and its business. Judge Ryan mentioned the magistrates. There are 4 magistrate courts, which I may be a little off base here, but the salary for a magistrate court judge is very, very low, based upon Kansas state statutes, I guess. So the county supplements that salary and allows a magistrate judge to serve at the same salary level as a district court judge. We also provide much of the support staff, supporting the operations of the court as well as supporting the judges. And it's really too bad. The state has not given those employees raises for, what, 8 years, something like that. The county employees that are supported receive the same raises that all county employees. So we have this very large differential between the employees supported by the state and those by the county. And which means if there's ever an opening in one of those county employee positions, everybody who's supported by the state applies for that one job, naturally. But those are some of the interesting things that the county does have an important role in supporting our district court judges. You know, the county appears before district court judges and other judges, the appeals court. I don't know whether we've been, well, I guess we did have one statewide issue before the Supreme Court recently, but you know, we've lost, we've won. And you know, I think in all of this, these folks can't say it, but I think we've come to a point, let me back up. All of us who serve an elected office, whether city, county, or state, we swear to uphold the state's constitution. And that should be our primary focus. And the arbiter of whether or not that occurs is the ultimate Kansas Supreme Court. So we should, as elected officials, should not be surprised if, in fact, we take actions that's contrary to the Constitution, that a decision would be made not supporting that action that we've taken. And I think that's where all of this has come down to. There are specific ideologies that are not supported necessarily by any kind of constitutional writing, and that because of that, the system was tried to be changed unsuccessfully. And so now there are special interests who are trying to change the system without changing the system by eliminating great people who serve on our judicial panels. So I hope you'll go down that list and retain the judges that we have. I think it would be a big step back if in fact that does not happen. Let me mention from the county's standpoint, we do have an important issue on the ballot. It'll be the last one on the ballot, and that is whether or not we're going to have a new courthouse supported by a 1/4-cent sales tax, or whether or not we will have to renovate the existing courthouse supported by property tax. And that's a decision that we've been looking at since about 2003. I came on the commission in 2007. That was the first big project we looked at. We focused on the recession, getting through the recession, and we've had, I think, 3 or 4 consultants look at it. Every consultant comes back with the recommendation, you need a new courthouse. In 2012, we gathered together about a 15-member citizens committee to look at that question. Their recommendation was you need a new courthouse. In addition to that, Johnson County has never had a corners facility. We rent space in a Wyandotte County, I call it a Butler building. In my days as a farm boy, we were familiar with Butler buildings, and that's basically what we have. We do 250 autopsies a year. Our fees, in 2015, we paid this private facility $283,000. They do not have the ability to do on-site toxicology and much of the other research that needs to support the coroner's conclusions. We send that out to a spatial lab in St. Louis, and that cost us about $55,000 in fees in 2015. I'm not saying that we can save that money, but that money would stay in Johnson County and support the personnel that we would need to have a first-class coroner's facility. You know, those 250,000 cases are not all criminal. Most of them involve elder abuse questions, or a family who has a member who passed away with an unattended death, unexpected death. And so they need to know whether there's something hereditary or other biological issue that could impact the rest of the family. And because of the fact that we don't have our own facility, we cannot prioritize those. And families have had to wait 3-4 weeks to get those results back. And if I have to go in and identify a loved one in the current facility, there will be 4 or 5 other autopsy cases in the same room. Or if the district attorney has to observe the autopsy on a criminal case, he has to stand right there by the coroner and is subject to a biological contamination, and it's a health risk for those who have to observe. Kansas City, Missouri has a new coroner's facility a couple of years ago. My first question was, well, why don't we contract with them? They have up-to-date equipment. They're busy. They're full. They have contracts with 5 Missouri counties. They have no space for us. So those 2 questions, it will require a 1/4-cent sales tax. It expires in 10 years. And I think it's very, very important that we be able to make an investment in a new facility rather than have to make an equal sum of investment in a facility that's 60 to 50 years old. And to me, that doesn't make sense to invest those kind of dollars in a facility that when we're done will be 80 or 90 years old. So appreciate your support. I know this group has looked at that question, I think 2 years ago, Janice told me, and have come to the conclusion that we need a new one. We have an active advocacy group The county cannot say vote yes or no in any of our material. We can provide educational material, and I have some of that with me. As to the question of the quarter-cent sales tax, most of the pushback comes from, you know, our sales taxes are pretty high right now. And that is an issue. But let me put this quarter-cent in perspective. On a $20 t-shirt, that's a nickel more. On that $1,000 refrigerator, that means an additional $2.50. And on a $30,000 automobile purchase, that's another $75. I think that small increase in any of those purchases is probably not going to cause any of us to delay a purchase or make a non-purchase decision. So anyway, we have a website, jocopublicsafety.org. Much information is there. We have the advocacy group who's out working. Most of our effort will be in social media. And so go to, I think the website is Vote Yes for Public Safety. And use your own social media contacts if you would like. And provide links to the county and to the advocacy group. That will be a big, big help. So appreciate your effort. I have some brochures, not enough for everybody, but I'll leave them. Thank you very much.
Thank you, and we are over time. I'd like to let you know that the league also does courthouse presentations. I'll turn this back over to our president or special director to dismiss us.
Thank you so much for your patience, but wouldn't you agree that this panel has given us so much to think about, to advocate for? I cannot thank the four of you enough. Thank you so, so much.